Yes.
It is 12 o'clock, and I'm going to open up the workshop. It is October 14th, and our workshop today is for continued discussion on the special taxing district and also the resolutions. Everyone received 4 attachments in their email to take a look at, and currently continue to digest that information. And I think the purpose of the day's meeting is to continue to educate ourselves on this district. I want to stress that we won't take any action, maybe not until November or maybe even later. But I want to make sure that we all feel comfortable with this. I want to make sure that the public has had a lot of input if they want to put any input on this. And we all must feel comfortable before we move forward. So I think with that, Lou, where are we at with this?
Well, I think Kimberly's on here somewhere.
She was. There she is. Hold on. I keep asking her.
Yes, I'm here. I'm here.
And I believe that someone from Unicap was also going to be on too to answer any questions, but I don't know, as all the members of the board carefully read through each of these resolutions, because there's a lot involved here. It's not just the special taxing district, but the resolution authorizes that there's a tax, a special tax that'll be collected from all real and personal property in that district, that it'll be distributed into or put into a special fund. And then that fund will be allocated towards paying public improvements, as well as any expenses that are allowed under the Local Government Article Act that's allocates that or authorizes this to be done. And I'm a month and a half shy of 30 years. I've never been involved in one of these before, so it's new to me too. And I'm sure it's new to the town of Elkton. So that's why I've been so cautious in our approach here. The people that are proponents of this, obviously the developer and his associates, council, Unicap, and all that, they're familiar with it, but we're not. So it's a matter of just bringing us up to speed on what's involved. But I urge you to read carefully through that, because ultimately when you make a decision one way or the other, you're responsible. I can advise you, but I'm falling back on Gene Herman's advice many years ago. I can throw my 2 cents into the ring, but I'm not the decision maker.
Louis, one of the biggest things I've read in there was some of the people that have already been using this was not informed at the beginning. That was one of the key things I read in there. But with this tax districting we're doing, most of the people that are buying these properties will already be informed of what they're getting into, right? That's one of the key things that we're doing, that some of the places like with Prince George or wherever the places I read, they haven't really been informed at the beginning of this. You understand?
That question is a good question, and according to the resolutions, there has to be a declaration of this special tax that's recorded with the county land records, I suppose, that'll go along with these properties. And I sent an email to the assistant town administrator in Brunswick, Maryland, to find out if those people had not been informed. It would be up to the realtor, and that when they sell the property, the realtor and the attorney represents them in settlement to inform them. I couldn't figure out why they wouldn't have been informed.
The statement wasn't so much that the people were not informed. According to Mr. Dunn, when I talked to him yesterday, he said that people had said that they were not aware that they were paying the special tax, that they were part of this district, but it wasn't that they weren't particularly informed. He said they could possibly have missed it at settlement, all the different forms they're signing, et cetera, et cetera. But that was just the biggest deal, the biggest issue that people had, that And even if they had been informed at settlement, if they're new to the area, they're now talking to somebody who lives in an older section of Brunswick and that person doesn't pay their tax. I can understand why someone who's new to the area would say, hey, I didn't know that, et cetera, et cetera. But he never gave me the impression that he thought that people were being underhanded and hadn't told anybody.
That's
That was-
something.
That was my impression as I read it, because it says many of the homeowners were stated they weren't aware, but if some of them were aware, I would assume that the information was given to them, and like you
It would
said,
have had
they
to have
missed
been.
it.
Good afternoon. This is Emily Metzler. I'm with Municap. I can tell you that for that particular transaction, that's one of many special taxing districts within Maryland that we currently administer. Meaning once the bonds were issued, we assist the jurisdiction with levying the special tax and ensuring that the homeowners know about the special tax. There's two forms of disclosure when you have a special tax in a district. There's legal disclosure and then there's practical disclosure. And I can tell you that for this district and all other special taxing districts, we give both. The legal disclosure is the lien on the property. We levy the special tax and it creates a legal lien, and then we record that in the land record. Now, most homeowners don't go look at that when they close on a home. They should, but they don't. So what we also do is provide practical disclosure. The practical disclosure is when builders take down lots, we do ensure that they get a document acknowledging the special tax. And when homeowners purchase the property, we as the administrator do a couple things. We offer to meet with the home sellers to those lot purchasers to provide education. So as they're going through the closing process, they know to include that special tax in their closing documentation. But then those sellers are also informed about the special tax. For resales in the future, we also do ask that any HOA documents include a notice on the special tax, and that helps with resales in the future. Existing homeowners aren't necessarily required to provide information on the special tax. However, we do find if the information is included in the HOA paperwork, which is required to be provided, that future homeowners are made aware of that.
And if there's no homeowners association established, then that's going to be up to what? The individual buyer's attorney?
It is, right. So it is show up when you do a property search at the home purchasing process. So it does show up in the paperwork, no different than when they prepare the escrow agreement to show their taxes in the future. Usually the real estate agents will prepare an escrow agreement. Because the special taxes are levied and billed at the same time and as the same manner as the real property taxes, the special tax will also show up at that time in the closing process.
Okay.
Separate from everything else?
There's a separate line item on the tax bill, but it should show up on the same tax bill. The county will bill and collect it at the same time and in the same manner as the real property taxes. Once the county collects it, they will remit it back to the town for the special fund to pay the debt service.
Emily, I have
I'm
a
sorry.
question.
Okay.
I'm sorry.
No, go ahead, please.
No, the question I had is the resolution calls for a special tax applied to both real estate and personal property. How is the personal property collected? The county doesn't collect that, I don't believe.
Actually, it is required to be levied on both, but when we prepare the rate and method of apportionment, we set the rate on personal property at 0. So essentially, we are having a levy, but the levy is 0 so that we don't have to collect it from personal property in the future. So if you look in the details of the rate and method, you will see that the rate on personal property is 0.
Okay, if that's the case, that if it's 0 and there's no intent under this resolution to collect personal property, we'll eliminate that from that resolution. We don't want people to say it's on personal property, especially of business owners, and then they're under the RMA, it's 0. So
I'm
it's
not
essentially,
sure.
we'll just eliminate that language altogether.
Yeah, and I'm not sure about the legal requirements there. I believe, I think an attorney should speak to the requirements of what it needs to be in the resolution. So I would defer to your counsel on that.
Okay, I understand. because we want this to be accurate, and I don't know enough about that language, but it actually says personal property, and we're not going, our intent is not to do it. So I would eliminate it altogether unless council has some other reason we have to leave it in there, or unless it changes in the future somehow. I don't know.
I agree with you. I agree with you, Lou, on that one. Absolutely. So John, will you be
Emily,
able to-
has it been, because I know oh, I'm sorry, Commissioner.
you're fine. You're fine.
Kimberly, you are on.
Be there.
You need to
Yeah,
render-
sorry, I'm having trouble with the mute issue, so.
The,
Um,
the
what I was
question was, could we just eliminate the personal property tax in the
Yes.
resolution?
You can if you want. I mean, if it's not intended or underwritten to be recorded, I'm sure that's just something sure the bondholders know it's just on the real property and not any personal property, and that can be removed. The statute permits you to tax both, but if we're just doing the real property, we can certainly keep it limited to that.
I think that would make more sense. Because we collect the personal property tax, and I think it would, we're not going to be doing that. So it's better if it's just removed.
And then another comment, we're obligated under this resolution, once it's enacted, to make sure that all special taxes are allocated to a special fund under which the expenses and public improvements are paid. So if we have no intent to collect any personal property and tax and then allocate it to this fund, I don't even want it in there. It doesn't make sense that you would. So I'll take council's advice, or she'll take my advice, or we'll take each other's advice and eliminate that from the resolution.
Okay.
Is it the question I have from the board essentially at this point is there an issue with the property owners paying this special tax? Because we actually know what it's going to be. I mean, this RMA, that rate and apportionment thing that they did, analysis, shows what that tax is going to be.
Can you reiterate that amount for me, Lou? Because I got to apologize. I was losing my emails for some reason. I don't know why they were deleting themselves. So I didn't have that one where it says it starts at 400 and maxes out at something.
On table A, it's the Word document. They have a signed special tax commencement date. And on residential property, it looks like it's $492.
Yeah, that's it.
Per unit, which would mean per unit would be per house, per apartment, per townhouse unit. The hotel property would be at $832 per room.
Oh my God.
The mixed retail property would be at $812 per 1,000 square foot of commercial property. The office property would be at $1,304 per 1,000 square feet. The sports indoor property on the indoor facility would be $969 per acre. So I think they're taking X amount of acres, so it'd be $969 per acre. The sports outdoor property would also be priced per acre, which is $305 per acre. The marina property, which who knows if that'll ever happen, but it's at $1,772 per slip. And there's no approvals on any marina property or any approvals on any of that. We haven't seen any of that, but they've got that based in there.
Well, Rob, all these prices that are being put out here, like for instance, we don't even know if there's going to be a marina. So that's $1,772 per slip that we're not able to calculate or count on, so to speak. So how do they come up with these numbers based on information like that,
Just
I
injected.
don't understand how they derive these amounts. And how did
Is
they?
Emily on here still, or?
Yeah, Emily's still on.
Okay,
And
she's,
here,
she can
Keenan
tell you that.
Rice is also on the line from Unicap here. And I think that's a great question that you're asking about how these rates were determined, because it's important to understand that the rates that are being levied on the development are palatable. We certainly don't want to levy a special tax that would impair the ability for the builders and developers to sell the property, and we certainly wouldn't want to overtax the future buyers of the property so much that they wouldn't be able to pay these amounts. We do allocate the special taxes based on an equal share of benefit that each of the parties receive, and so the varying rates are set so that we're allocating the special tax amongst different property taxes based on that benefit. Now, the rates that you see here are established based on the cost of the improvements to be provided and then allocated to the different development based on their share of the cost. And so essentially, we're going to take the cost of the infrastructure that we would like to finance and we spread it amongst the future development. Now, you mentioned an important question about the marina property and some of these properties that are not yet permitted or, within the appropriate PUD areas. And what I can tell you is we did take those properties into consideration. And when we allocated the special tax, we will size the costs and the amount of bonds that would be issued so that we would not have to rely on those special taxes immediately. That way we aren't getting ourselves into a situation where we don't have adequate coverage on the bonds. However, to the extent those development pieces do come online, it's prudent that they would share in those improvements in the infrastructure. And as such, we believe that they would need to contribute to that cost at some point. So we do create classes for them and rates for them for in the future, but we would only issue bonds in an amount that would cover the initial cost. One other point that I want to make about these rates, is as we set these rates, we do speak with the developer team and get input that he's getting from his buyers to ensure we did not set these rates in an amount that is inconsistent with the agreements he has in place. That was very important to us, that it wasn't outside of the realm of what he is already talking to and palatable. And to the extent we don't have these special taxes in place, ultimately the builders are going to take that cost of the infrastructure that they would then have to pay for, and they're going to pass it through either in the land sale price or the future home sale price. The nice part about this type of financing is that we're able to levy the special taxes and pay for this financing up front in one cohesive manner. And it really makes it easier and maybe even more cost efficient to provide this infrastructure up front. And so ultimately, the end user is going to pay for this cost. We believe that this is the most cost efficient and easiest way to do this to allow for the future development of this project.
Emily, I want you to explain that the rates that the mayor called off were assigned special taxes, but there's also a maximum special tax too. I think it's 10% higher than those numbers.
That's correct. We do ultimately collect at the assigned special tax rate, but when we levy the special tax, because these bonds are being issued out into the market, we also have a maximum which allows us to collect up to a 10% coverage on the bonds. Investors like to know that there's some coverage built in the case that we would have collection issues or just our ability to pay the debt service. However, the developed property will pay at the assigned special taxes. They will not have to pay up to the maximum unless we need to collect an amount to get to the full share of debt service each year.
Also, you want to comment that each year the tax rate will go up 102%.
Right. So the debt service is set to increase by 2% per year. And as such, we levy the special tax that each year it also increases from the first year at 2%. That's consistent generally with what we see on changes in real estate taxes. We generally see inflation over time. I would say that 2% is probably a little bit conservative. So it's not an uncommon practice when you look at special taxes or taxes that are levied on property. What this allows us to do, again, is finance more cost up front and then amortize that cost over time.
Does the board have any other questions specifically about the special tax that will be collected and allocated to the special taxing fund or tax fund?
I guess my only question is, like, for a residential property owner, it's $492. And at the end of 30 years, it went up to what? Was it 8 something? Anybody remember?
Yeah, Steve did that calculation, but I'm not sure. I don't have it in front of me. I just, it's 2% per year.
It was like 800 and something a year, right? That they would be paying. Okay. So are these numbers pretty concrete? Is there anything that's going to come back on us and say, well, the costs were a little bit higher than we estimated, so therefore that 492 is now going to be 550, something to that effect?
No, ma'am. When we levy the special tax, we're levying it at the maximum. So they can go down, but they cannot go up without your further approval.
So it's going to start out at 492 per residential lot, and all the other numbers that we were given, or that's all the starting points?
Yes, ma'am.
Okay. All right. That's good to know. And I'm going to ask a really crazy question. What if over the 30 years you collect more than the debt? What happens? Is that something that investors just?
We don't. So we don't. There's no crazy question. It is a complicated structure. So I actually appreciate your questions. They're good questions. Each year, the amount that we collect in the special taxes is set to equal the amount of debt service that we need to collect. So we will not collect more than what is necessary to repay the bonds.
Okay. And Mr. Jackson said at the last meeting, I go back and forth with this a lot personally, I guess you can tell, but he said something about this would include, the water tower, the infrastructure, all that. And then he mentioned Route 40 and 213. That's a huge undertaking, I would imagine, that I was surprised to learn, would have to be done for this particular PUD. But I was just wondering, is that a large portion of the cost? Does anybody have a clue what something like that is adding to this debt?
I keep thinking it was over 3 million. I saw somewhere in there.
Did you?
Yeah, so it'll be provided, I'm sorry to interrupt, it'll be provided that, the special taxes are only available to be used for the debt service. Once that's paid off, great question, and they'll no longer be collected.
So it could be an early payoff for the property owners. Is that what you're saying?
The numbers aren't set up that way. They're, designed to be sort of precise. But
okay.
If a homeowner, for example, chose to prepay their own, then it could end early. Or if there were some other, if there was a miscalculation in a way that, that the folks were overpaying, say, $10 a year, then yeah, it would end sooner. There aren't going to be more taxes collected than the debt service that has to be paid down.
Okay, thank you.
One of the other comments or questions I have, and I'd just like to hear it one more time, is that the obligation there's no obligation on the town of Elkton's shoulders. Is that correct? If there's a shortfall of dollars coming through, there's no responsibility for the town or other residents of the town to have to pay into this. Is that correct?
That's correct. We are not asking the town to back these bonds in any way, shape, or form, and only the parcels within the district will have the special tax levy. No parcels outside of the district will be impacted.
Very good.
This is Kimberly. Correct. The town is not responsible. It will say that in the bond. It says that in the resolution. It will say that in the bond documents, and there will be no mistake, including in the disclosure to the bond purchasers, that the town is not responsible for 1 penny of this repayment.
Very good.
Yeah.
Is there any specific questions while we've got the experts on here from the board?
I had a question.
Go ahead, Jeannie.
Are there administrative duties that the town is obligated under this special taxing district to carry out?
There
So
are,
this is Kimberly, or go ahead, Emily.
I'm sorry. Sorry,
Go
Kimberly.
for it. Go for it, because then you can describe what MuniCap is doing.
Sure. So there are administrative duties required following an issuance of bonds. On the topic of costs, those will also not be covered by the town. Those are paid out of the bond proceeds. But just to give you an idea of what those costs could include, there will be a trustee in place. If there are any bond counsel requirements, that would be covered in that cost. And then the cost of the administrator. The administrator, MuniCap, would assist with any ongoing continuing disclosure compliance, as well as any reporting to Emma, dissemination agent work, and quarterly disclosures from the developer. There may also be collection costs on the town of the county, and again, those all would be covered under the administrative costs bucket, and that entire bucket would be paid out of the special taxes and not expected to be paid by the town.
Perfect.
Mm-hmm.
Is there any questions from the board that you would like to have answered, or any comments? And I want to continue to stress, we're not taking any action on this at the next meeting, or maybe even not the following meeting, but I just want us to completely digest this, understand it. It's a different way of doing things for us. And who knows, it could be a trend of the future for us. But we want to make sure that we're doing this correctly, safely, for the best interests of the town of Elkton.
Yes, I have a question. I came away from the last meeting under the impression that this had been done in several locations throughout the state. But we received an email from Mr. Peck from the MML stating that this is just about the only municipality in Maryland was the district in Brunswick. I know there's got to be more, but we are not provided with that information. Can we get that information as to other areas that have been developed in this way?
Yes, sir. Again, this is Emily Metzler, and I can confirm that there are many other special taxing districts that have been approved not only within counties, but in local municipalities. I did send around a short list yesterday of some of those projects. We highlighted 5 or 6 special taxing districts that were also mixed use, so that you could get an idea for other projects similar to Southfield that have both a residential and a commercial component. Beyond just a pure special taxing district, I can tell you that there are many other special taxing districts that also have a TIF component in them in the state of Maryland. I didn't provide that in the list because that is not exactly like the structure proposed here, but I can assure you that there is an extensive list of special taxing districts already approved within Maryland and successfully being implemented at this time.
Thank you.
Emily, I have a question if the commissioners are on the back burner for a minute. the special taxing district and the collection of special taxes is based on the premise that this will be built, that there'll be enough homes and property ownership in order to subsidize the debt service on these bonds along with other expenses. We don't know the risk factor here in this. I mean, locally, I've not seen so many houses being built at such a slow pace. I don't see how they're going to collect all this money to pay this debt service. But they seem to say there's a market study or something, but we don't fully I don't fully understand how you can do that. I just in this area, because I've been here a long time and I'm looking at the houses being built, and there just ain't that many houses going up here to subsidize serious debt on $12 million worth of infrastructure.
Sure. So that's a great question as well, and I can understand your concern for that risk. I want to mention 3 points that I think are relevant to your question. One, I just want to reiterate that development risk is not a risk of the town. Again, you have no obligation to step in if for some reason those special taxes weren't available to pay the debt service. I just want to make that clear. Number two, as we go through the bond process, we understand that risk, and we're going to take specific measures to mitigate that risk. You're correct, and you were told accurately that prior to the issuance of bonds, we're going to have several studies prepared to determine that the development going forward and necessary to pay for this debt service is actually going to occur. We're going to look to ensure that there are permits, there is financing in place, there will be an appraisal done on the value of the land. An engineer will come in and tell us that necessary approvals are in place and that the infrastructure and costs are sound. And then ultimately we'll look at a market study, and the market study is going to look at all of the development proposed to be built, and it's going to tell us whether or not we have that risk. We have not yet asked for those studies because it's too early to do that in the process. We typically want to have the legislation in place first, but we will have those studies to look at that risk there. The third point I want to make is that the order of the priority of the special taxes to be collected are collected first from the developed property. But to the extent that developed property is not there, we will also go back and collect the special taxes from the undeveloped property. So that's great for two reasons. One, the special tax is levied on the land, and we can assure that we're going to collect it even if there isn't developed property out there. But two, it incentivizes the landowners to develop the properties, bringing forward the development that's going to create other great taxes and economic benefits for the town, because they don't want to pay the special tax on undeveloped land. They want to transfer that special tax to the end user. So there's 3 ways, again, that we'll look to mitigate that risk. One is it's not your risk. 2, we're going to prepare proper studies. And then 3, we have the undeveloped property to pay as a last short. The last thing, and actually there was 4 points, I'm sorry, is I just want to mention that the bondholders that purchase these bonds, they're familiar with that risk. They know development risk. And unlike general obligation bonds that may have a very low interest rate, because of the risk and the investors knowing that risk, these bonds tend to have a slightly higher interest rate. And that compensates those investors for that risk that they're taking.
I have concerns about any developer because they're all limited liability companies, and they're limited to their assets. So, you know, this thing could go belly up and still somebody's not going to get money, you know.
So there are fail-safes in place, and that's why we get the appraisal, because the investors want to know that there's adequate value in the land related to the amount of bonds that we're issuing. If for some reason that developer, which will prepare, will look significantly at the due diligence and their wherewithal to pay that special tax, if, for example, the special tax falls on the undeveloped land. But if, for example, they do not pay that special tax, then the investors can take title to the land and find a new developer to come in and build the property. It may be a little bit longer, it may be a different developer, but I also, have seen that the investors are going to look to the property as their security and not the developer.
Is that a foreclosure process or what?
Keenan, can you speak to that?
This is Kimberly. It would act similarly to a tax sale process, and then, you know, when the property's sold, it would be, you know, assessed and applied to the lien that's there. You know, the bondholders understand that, you know, that's an, you know, hopefully an unlikely result, but that's the security that they've bargained for, which, you know, as we can, you know, certainly repeat more than once, is not going to be the responsibility of the town.
This is Keenan Rice, and just to add a few comments to that, Louis, you're of the same mind as the bond investors. They don't want to look to a developer because they know they have limited liability corporations. They're really looking to the property. They require a security interest in the real property, and they want to have an appraisal done to see what the value of that property is. And there's a special tax levied on that land. And so to the extent the developer or these builders haven't developed their property or sold the property, the owner of the land has to pay a special tax to pay the bonds. That special tax is like any other tax. If it's not paid, the property goes to tax sale. And Maryland has a great tax sale process. In fact, we work in 30 states through the country, and there's not any state I work in that has a more effective and efficient tax sale process than Maryland. So in Maryland, we normally collect the delinquent taxes pretty soon. Usually we'll see that the lender for the developer will pay the special tax, because the special tax is a priority lien to that mortgage by their construction lender. But if the lender doesn't pay it, then usually some other developer or builder will come in and pay it, because they can get the property just for that annual special tax, which is an incredibly good deal. But if none of that works, the investors take that risk, you know, and they're getting a higher interest rate, you know, compared to the interest rate you would get if you were to issue your own bonds. The investors are getting a higher interest rate because they're taking that risk. Now, I can tell you from experience, it's extremely rare it gets to that point. But if it did, the investors take that risk. You're not taking that risk. But the investors are going to want to know before they invest their money that they don't want to see the property going to tax sale either. So they want to be comfortable, number one, with the market, that there will be home buyers and, you know, the property will move forward. Then number two, they want to be comfortable with the value of the property so that they know it's worthwhile for the owner to pay that tax. And if the owner doesn't pay it, someone else will step in and pay it, because it's really very low compared to the value of the property. So that was a very good question, but that's something the investors will be looking at, and the documentation we'll be providing to them will address those questions, because they're putting up their money and they need good answers to those questions, because they can't look to you to pay that tax.
As an appraisal on these properties, the ones that are within the special taxing district, has that been completed?
It will before the bonds are issued.
Okay, but not yet though.
Not yet, because it needs to be dated pretty close to the issuance of the bonds.
Okay.
Together, and I
don't see Earl. Earl's gone.
We're missing.
Should have one of those cardboard things like they use in stadiums.
I think he had someone at his door. Is there any other questions from the board? Staff?
No, I think it's a good suggestion that we're taking a slower pace to come up with some answers. Certainly it's good to hear that Elkton's not going to be obligated for anything. And certainly a lot of questions that were asked, I guess we're on the same page. And some of those same questions I asked Louis the other day. And, you know, Earl picked up the very first question that we saw in the report. But we still got time to go on this, because there's a wealth of information. And each day it seems like it's just more and more and more and more. I have notes and I'm taking more notes, but that's fine.
Thank you, Charles.
I want to comment, Mayor, that today's discussion is not the end of it. It's just a process in which we're continuing to discuss this, because the board is not obligated to ask all the questions that come to their mind today. We can send it to them by email. We can have another discussion or whatever. And until everyone's very, very comfortable, I don't think we'll act on anything.
Hey, Mayor, it's Commissioner Piner again. I'm sorry I had to walk away. I had an important phone call I had to answer. But listen, on that first statement that I made, again, I was insinuating that I did say that a lot of people were not aware of the prices. It's almost like the insurance when you give a proposal and you talk to an insurance client. At the end, they don't remember some of the things that you went over, and you even have them sign off, check off that they were understood that some of the provisions that they signed for. So I understand that some people may not had understood the tax that was added into their cost, but I wasn't insinuating that they didn't know. It's just that that's what I read from the statement that we received. So I'm fine with everything so far. I'm happy with the help that we've been getting from Emily and Kimberly and all of our support from our town. So I just thank all y'all for chiming in and helping us out.
Thank you. Does anyone from the public have anything to ask the experts while we've got them here today? If you do, just unmute yourself and state your name and ask your question to the experts. I see none. Any other questions, comments? Lou, any more?
Well, the only
Mr.
other
Mayor, can I
thing-
make a comment? Mr. Mayor, this is John Downs. Can I make a comment?
Yeah, John, go ahead.
Okay. In my capacity as a private attorney in matters not related to the town, I interact with realtors on a regular basis, if not a daily basis. And if you ask 10 realtors in Cecil County, what is the number one problem in the real estate market? They'll tell you there's not enough inventory. And that's why the houses are selling consistently above the asking price. And that I realize that in 2 years, that circumstance could change, but that's the state of the real estate market today from the comments that I get from people who, barely know each other, but they're telling me the same thing. And so that just addresses the issue of, will these people be able to sell houses? As long as they have them priced reasonably, and I don't see any reason why they would price a house to such a point that they don't think that they could sell it, but the demand is there.
Thank you, John.
The comment the other item we had to discuss today was resolution R9, the issuance of special obligation bonds, but actually R8's the more important one because that's the special taxing district you need to establish before you ever issue any bonds. So I think we probably all have to give the R8, for lack of a better term, that the highest priority consideration at this point, because if the board's comfortable ultimately with the special taxing district and all the provisions in that, then it'll be obvious that we'll have to agree to issue bonds because that's how everything's paid for.
I agree 100% with you, Lou.
So I don't know if there has any other questions, but I think we've pretty much covered it today.
I think so too.
Yeah,
Well, listen,
Mr.
I
Mayor,
appreciate.
Mr.
Yes.
Mayor,
Yes, Mr. Casey.
If I may, I just wanted to address what Commissioner Piner said about homeowners receiving notice of special tax, and we hear about this from time to time, and I just wanted to tell you the safeguards that would be put in place for a transaction like this. First of all, with regard to any home sales, we would have the developer post a notice with regard to special tax if the town determines to levy such a tax. Also, as Mr. Rice said earlier, this is treated for all purposes of state law and federal law as a tax. And in other words, when a homeowner purchases a home, they are required to be provided notice with the expected taxes, state and local taxes. The information concerning the special tax would also be provided to them, as well as expected water and sewer fees and other assessments. So we put that in place, and then the developer will also have agreements with any home builders by contract that they are to provide this information concerning the levy of the special tax to any homeowners. So, more than we do with other governmental charges, we try to address the issue in as much notice as possible. And yes, as the commissioner said, sometimes people say, I wasn't told, but that happens. But we recognize that, and your professional team will take safeguards to make sure that potential buyers do understand that, just as they would understand that they have to pay traditional property taxes, just as they understand that they would have to pay water and sewer fees and any other municipal charges. So I just wanted to mention those safeguards that would be put in place should you choose to move forward.
Thank you so much for that information. Any last comments?
I'm sorry, I didn't interrupt you. I don't have any comments on R8 or 9, but I want to comment that the Board of Public Works is going to look at the Armory on the 21st, next Wednesday. And I'm pretty sure they're going to authorize the sale of the town. So we're getting close to owning the Elkton Armory.
Fantastic. Fantastic. Thank you, Lou. I know that's been, I've read the emails that's going back and forth.
Yeah.
I couldn't imagine how many emails have gone back and forth since the start of this process. And it's, I wouldn't be scared to say it's 500 to 600 emails that you've gone back and forth with this group.
Oh, they killed a lot of trees, I can tell you.
It would have been.
Putting this stuff out.
Well, thank you, everybody. This meeting is adjourned.
Okay.